Welcome back, future criminologists. In this video, I will be discussing criminal jurisdiction, requisites for the exercise of criminal jurisdiction, and the principle of adherence of jurisdiction. Before discussing what is criminal jurisdiction, let us define first what is jurisdiction in general. Jurisdiction is the power of a court to hear and decide cases. Absent jurisdiction, convictions and court-ordered sentences are void. The word jurisdiction was derived from the Latin words juris and dico, which literally means I speak of the law. In criminal law, jurisdiction includes the power to impose punishment. From the concepts mentioned, we can now define what is criminal jurisdiction. Criminal jurisdiction is a term used to describe the power of courts to hear a case brought by a state accusing a defendant of the commission of a crime. How jurisdiction is conferred? Jurisdiction is conferred by substantive law. For example, Republic Act No. 9165 or the Comprehensive Dangerous Drugs Act of 2002, which is a substantive law, states that the Supreme Court shall designate special courts from among the existing regional trial courts in each judicial region to exclusively try and hear cases involving violations of the said act. Thus, by virtue of the said substantive law, it is the regional trial court, designated as drugs court, which has jurisdiction over drugs cases. The question now is, what substantive law determines the jurisdiction of the court? The statute or law in force at the time of the institution of the action determines the jurisdiction of the court over the subject matter and not at the time of its commission, even if the penalty that may be imposed at the time of its commission is less and does not fall under the court's jurisdiction. For example, accused raped the victim in the year 2000. However, the crime was discovered in the year 2020. Assuming in the year 2000, it is the municipal trial court which has jurisdiction over rape cases, while in the year 2020, the crime of rape is already within the jurisdiction of the regional trial court. If a criminal action will be instituted against the accused in the year 2020, it will now be the regional trial court who will try the case and not MTC. In case you are wondering, even though there is 20-year gap in the given problem, the action did not yet prescribe. This topic on prescription of penalty will be discussed in a separate video, so subscribe to be notified in our upcoming uploads. Next question. How? Take note, the question is how criminal jurisdiction is determined. While jurisdiction of courts is conferred by law, jurisdiction over the criminal case is determined by the allegations in the complaint or information. Now we go to the requisites for the exercise of criminal jurisdiction. The following are the requisites for the exercise of criminal jurisdiction. 1. Jurisdiction over the subject matter. 2. Jurisdiction over the territory. And 3. Jurisdiction over the person of the accused. Let's discuss each. Jurisdiction over the subject matter. Jurisdiction over the subject matter is the power to deal with the general subject involved in the action, and it means not simply jurisdiction of the particular case then occupying the attention of the court, but jurisdiction of the class of cases to which the particular case belongs. Jurisdiction over the subject matter is derived from the law. It cannot never be acquired solely by consent of the accused. Objection that the court has no jurisdiction over the subject matter may be made at any stage of the proceeding, and the right to make such objection is never waived. For example, now we go back to Republic Act No. 9165 or the Comprehensive Dangerous Drugs Act of 2002. The said law states that it is the regional trial court which was designated as drugs courts shall have jurisdiction over drugs cases. The law is clear, thus the accused cannot consent that his case will be tried by the municipal trial court. Jurisdiction over the territory. Jurisdiction over the territory states that, as a rule, in all criminal prosecutions, the action shall be instituted and tried in the court of the municipality or territory wherein the offense was committed or where any one of the essential ingredients took place. For example, the accused is a resident in Makati and the victim is a resident in Bulacan. The accused raped the victim in Quezon City. Where should the criminal action be filed? The criminal action should be instituted in Quezon City or the municipality or territory where the offense was committed. What are the exceptions to the rule, or instances where the criminal action is instituted in a place other than the municipality or territory where the offense was committed or where any one of the essential ingredients took place? The exceptions are as follows. 1. Circumstances under Article 2 of the Revised Penal Code or the principle of extraterritoriality. This is already discussed in our previous video. 2. Where the Supreme Court, pursuant to its constitutional powers, orders a change of venue or place of trial to avoid a miscarriage of justice. 3. When an offense is committed in a train, aircraft, or other public or private vehicle in the course of its trip. In this instance, the criminal action may be instituted and tried in the court of any municipality or territory where the said train, aircraft, or vehicle passed during its trip. 4. Where an offense is committed on board a vessel in the course of its voyage. The criminal action in this case is instituted in the court of first port of entry or of the municipality or territory where the vessel passed during its voyage. 5. Where the case is cognizable by the Sandigan Bayan. In this case, there is only one Sandigan Bayan, which is located in Quezon City. 6. In case of written defamation. In this case, the criminal action may be instituted where the alleged libelous article was printed and first published, where the offended party held office in case of public officer or the offended party's place of residence. Now we go to the third element, which is jurisdiction over the person of the accused. Jurisdiction over the person of the accused is the authority of the court, not over the subject matter of the criminal litigation, but over the person charged. It requires that the person charged must have been brought to its forum for trial, forcibly, by warrant of arrest, or upon his voluntary submission to the court. Rule in case of special appearance. A special appearance before the court to challenge the jurisdiction of the court over the person is not tantamount to estoppel or waiver of the objection and is not voluntary submission to the jurisdiction of the court. Principle of adherence of jurisdiction or continuing jurisdiction. It is a principle which states that Once a court acquired jurisdiction over a controversy, it shall continue to exercise such jurisdiction until final determination of the case, and the same is not affected by the subsequent legislation vesting jurisdiction over such proceeding in another tribunal. Jurisdiction being a matter of substantive law, the established rule is that statute enforced at the time of the commencement of the action determines jurisdiction. For example, the accused committed the crime of rape in 2015. The criminal action was filed with the regional trial court in the same year. In 2015, it is the regional trial court which has jurisdiction over rape cases. Let's say in 2019, there is no decision yet regarding the rape case and a new law was passed amending the jurisdiction of the regional trial court. The new law states that it is now the municipal trial court which has jurisdiction over rape cases. What will happen here now, based on the principle of adherence of jurisdiction, the RTC will continue to try the rape case and promulgate its decision later on. The regional trial court will not remand the case to the municipal trial court. At the same time, the accused cannot cause the dismissal of his rape case filed with the regional trial court by virtue of lack of jurisdiction. There are different kinds of jurisdiction. 1. Original and appellate jurisdiction. 2. Exclusive and concurrent jurisdiction. And 3. General and special jurisdiction. We will discuss these different kinds of jurisdiction in a separate video. To end, please subscribe to our channel and stay tuned for more videos.